Zuständigkeitsbereich des Bundesministeriums der Justiz, becoming effective April 19, 2006. This first settlement law, passed without the consent of the Federal Council of Germany, at the behest of the Allies, represents an important interference into our legal system. In particular, the respective Articles 1 of the introductory laws to the Gerichtsverfassungsgesetz or German Judicature Act, the German Code of Criminal Procedure, and the German Code of Civil Procedure are cancelled. Naturally, every layman says to himself, so what? Then they are cancelled. However, it is important to know that only in an introductory law of a law the territory within which a law is operative is defined, and that its declaration of coming into force can be found there only. In the introductory law, it is stated that the German Code of Civil Procedure, as an arbitrary example, becomes effective for the whole German Reich, let's say on November 1st, 1875. This way the territory or territorial scope is defined. Now it contains the declaration of coming into force with an exact date and the territory within which the legal norm is operative. Any legal norm, no matter whether it is an Administrative Offences Act, a basic law, a code of criminal procedure, or a criminal code, must define its territorial scope. If a legal norm is deprived of its comprehensible regional scope, it will lose its applicability because no one can define any more where it applies. This was done in the ersten Bereinigungsgesetz über Bundesrecht im Zuständigkeitsbereich des Bundesministeriums der Justiz, becoming effective 19th of June 2007, in particular for the German Code of Civil Procedure, the German Code of Criminal Procedure, and the German Judicature Act. But now some advice for all people who want to deal with the legal situation in more detail, and it is important for me to say that here again. Don't take for granted what is said, but start to check and to investigate yourself. And everyone who is interested in the legal situation in Germany and in what the basic law is, or maybe no longer is, can easily check and find out where the German basic law applies. There was namely formerly Article 23 of the Basic Law, which said the Basic Law was operative in the federal states of Hamburg, Bremen, Lower Saxony, Schleswig-Holstein, Bavaria, etc. If you look up that place nowadays, then you will find something very vague, faded, an allusion to some European integration. But this European integration is pointless, for Europe has not been constituted so far. And if you ask me, it cannot be foreseen that a European constitution with a clear territorial scope will ever exist. But once again, whoever wants to check it through a simple study of the German Basic Law can understand and find out that this Basic Law has no territory in which it is operative anymore. For at the end of the negotiations on the 4+2 treaty, there was the Paris Conference in July of 1990. And at that Paris conference on July 17, 1990, the FRG foreign minister at that time, Mr. Genscher, was summoned and told by James Baker, who was U.S. Secretary of State at that time, that the preamble to the German Basic Law and Article 23 of the Basic Law has been deleted without replacement. Thus the Basic Law for the Federal Republic of Germany, as well as the Federal Republic of Germany itself as a self-administration construct, had been abolished by the Allied victors. The same hour, on July 17, 1990, Mr. Markus Meckel, GDR foreign minister at that time, was summoned and had to attend upon Soviet foreign minister at that time, Mr. Shevardnadze. And as far as we remember them, the Soviets were not particularly tender and simply enacted the expiration of the GDR constitution on July 18, 1990 at midnight. The Allies gave and the Allies have taken away, and so it happened.
Genscher einbestellt und bekam die Weisung von Herrn James Baker, der war damals US-Außenminister, dass die Präambel zum Grundgesetz und der Artikel 23 des Grundgesetzes ersatzlos aufgehoben sind. Damit war das Grundgesetz für die Bundesrepublik Deutschland und damit auch die Bundesrepublik Deutschland selbst als ziviles Selbstverwaltungskonstrukt der alliierten Siegermächte aufgehoben. Zur selben Stunde, am 17. Juli 1990, wurde Markus Meckel, letzter DDR-Außenminister, in Paris einbestellt und hatte seine Aufwartung beim damaligen sowjetischen Außenminister Stefan-Andreas zu machen. Und so, wie wir sie in Erinnerung haben, waren die Sowjets ja etwas hemdsärmlich und die verfügten dann einfach, dass am 18. Juli 1990 0 Uhr die Verfassung der DDR erlischt. Die Alliierten haben es gegeben, die Alliierten haben es genommen. Und so ist es geschehen.
I may add that the so-called 4+2 Treaty, which has been signed on 12th of September 1990 in Moscow, that this treaty was actually done away with barely 2 weeks later by the Articles 2 and 4 of the Agreement for the Settlement of Certain Questions with respect to Berlin of September 25, 1990. De facto, this simply means that Germany was neither granted a sovereignty nor has it ever actually been released into liberty by the occupying forces in any way.
Weder eine Souveränität zugestanden bekommen hat, noch von den Besatzern tatsächlich je in die Freiheit entlassen worden ist, in irgendeiner Form.
Ja, das meinte ich vorhin mit der Situation, in die...
Yes, that's what I meant before, with the situation into which the Allies dismissed us in the year 1990, in the true sense of the word. For as I have just explained, by the decision at the Paris Conference, that is, by the abolition of Article 23 of the Basic Law in its older version, and by the abolition of the constitution of the GDR, the civilian self-administration systems of justice of the FRG and GDR have been executed with a blow. This means the last legal security which the Allied side granted us Germans after 8 of May 1945 was deleted, simply suspended, done away with through this event at the Paris Conference, and through the orders given by James Baker and Edward Shevardnadze. We were dismissed into this situation, and in place of that the Allied side negotiated a 4+2 treaty, of which the federal government claims to this day that it is a 2+4 treaty, but those who negotiated there were certainly the victors and not the defeated ones. The two constructs of occupation FRG and GDR were invited to this event as witnesses and as those who had to accept the instruction. If we take a closer look at this 4+2 treaty and examine its substance, then we have a product that carries within itself the impossibility of being fulfilled. In it there is talk that the united Germany is to be re-established, yet according to the legal position of the Allies, which is valid to the present day, the united Germany would have to include the FRG, the GDR, West Berlin, East Berlin, and the eastern territories of Germany. That would be the united Germany, for I point out, the Allied winners have promised us bindingly by law, by international law, in the Chef Law number 52 of August 2nd, 1945, that the nation German Empire is to be re-established after a period of occupation and after the granting of a peace treaty as a sovereign nation in the borders of December 31st, 1937.
Und die deutschen Ostgebiete umfassen. Das wäre das vereinte Deutschland. Denn ich erinnere daran, die alliierten Sieger haben uns im Chefgesetz Nummer 52 vom 2. August 1945 rechtsverbindlich, völkerrechtsverbindlich zugesagt, dass der Staat Deutsches Reich nach einer Besatzungszeit und nach der Gewährung eines Friedensvertrages als souveräner Staat in den Grenzen vom 31.12.1937 wiederherzustellen ist.
Why, if I may ask once again, the borders of 31st of December 1937? That is a good question. Why not the ones of 1st of April 1938, or the ones of 1st of September 1939? All of us know, some well, some not so well, the wheelings and dealings of that brown gang that did its atrocities at German expense for 12 years. We know about the adventurous expansions of territory which have been striven for there. Hardly a month passed in which somebody didn't allegedly plead to be incorporated into the German Empire, and there were were aggressive expansions of territory, entirely outside of any warlike disputes. And before the Allies passed the Chef Law number 52, they simply checked until when the borders of the Reich were undisputed borders, in other words, clean by international law, and in case of doubt, that applied until December 31st of 1937, and therefore the Allies laid down in this Chef Law number 52 of August 2nd, 1945, that the sovereign state German Empire